Taxation and black money. Wow, what a potent combination. Eh? And everybody can make money in this and turn black into white, right? Lawyers are going to advise of how to turn black into white. With due respect, no pun intended here, it's a complete classic statement I'm making. But the fact is, it's a problem which is there, but we also need the rightful money should come into the country. Having said that, we have a very interesting panel here, and let me just introduce in brevity the panel. So we have the session moderator, Mr. Krishan Malhotra, Head Taxation, Shardual, Amarchand. Then we have the panelist in Ms. Ishita, Sethi. She's a barrister from 7 Wentworth, Selborne Chambers, Sydney. Mr. Maran, Nandan, Principal Solicitor, Marsh Lawyers, Sydney. And Ms. Neha Malhotra, Executive Director, Nangia and Company. Without much ado, the stage is set for Neha to take over and with her presentation. And allow me to, in the meantime, go and pull in audience.
Good evening, everyone. I'm Neha from Nangia Advisors. And my topic today is black money, a menace. It really is a menace. And in this session, I want to take you through how far are we gone or how far we've done to create an antidote for this virus. Black money in general parlance is tax evaded money. But what does it do? It deprives us from the equality guaranteed in the Constitution of India. That's the day we are celebrating, right? Constitution of India Day. So, and National Law Day. But is the policy makers, have they provided us the equality yet? Not yet, I would say. But black money should be seen under two broad themes. One, which is redeemable, and the other, which is infected. And this infected black money is the point, which leads to all these illegal and criminal activities. It is used to do all these activities and it leads to generation of black money. So these infected black money has to be attacked. We need to ensure that it is no more there. But any law which wants to rein in this black money should be innovative. We have numerous laws in India, but how far have we gone to achieving the objective? Is the objective being achieved with so many laws in place? Not yet. So a global architecture is needed to smash and demolish these tax havens who are providing shields and encouraging black money by letting them park the illicit funds and keeping the beneficial owners and sources under wraps. So how did the Indian story start for the black money? It started with LGT Bank of Liechtenstein supplying 11 names of Indian account holders. But the game changer happened only when respected Sri Ram Jethmalani filed a writ petition before the Supreme Court seeking directions to bring back the illicit fund, the black money stashed abroad. Then only the game changer happened. And after that, we've seen an entire landscape of changes happening towards dealing with this issue. The Supreme Court ordered appointment of SIT, and then the NDA government actually set up the SIT in 2014. The finance minister rightly said his commitment he gave that tracking down and bringing back the wealth which legitimately belongs to us is their abiding commitment. And in that direction, in Finance Act 2015, it was provided that 2 independent laws shall be introduced, which will deal with the offshore accounted money and the dubious domestic activities, transactions that are happening to create domestic black money. The Black Money Act, which was to deal with offshore accounted money, came in. There was a window provided in there, and once that window was closed, people said that nothing is happening. Black Money Act is a failure. There's nothing happening. But here I think we are mistaken. The window was only a part of the Black Money Act. It only provided time to those who wanted to come clean. The story is not over yet. We are building up towards that solution. It did take incremental steps, and it has actually widened the net to catch the black money. But a much grave problem which is yet to be addressed is the domestic black money, and where the battle is going to be really long, because to cap the domestic black money is going to be a even more stringent activity. There have been steps which have been taken to unlock the domestic black money, but what is not yet been done is hitting the root cause of black money. Are we hitting the cause of black money by preventing generation of black money? No. There have been recommendations by SIT, and Benami Transaction Bill has been put before the Lok Sabha, and the root cause, that is prevention of generation of black money, is yet to be attacked. The SIT recommendations I would like to show are really effective if they are actually put in place. There should be a cap put on cash transactions, huge cash transactions. These are generally for illegal activities. Why can't there be a cap on these transactions? There is a cap given on a normal individual buying an AC more than 50,000, he has to show his PAN card. Does these small initiatives work towards getting those big bullets? No. There has to be a check on black money generation in education sector. The donations made to religious institutions, charities, cricket betting for that matter, all these places are where the black money is generated and then used for illegal activities, which is a problem for the worldwide economy. It's not only India which is getting hit by it. Now everyone can see the black money is creating problems for everyone. The illegal activities are not restricted to small activities anymore. The terrorism which we're facing is a fallback of these black money. Why can't we question a Cayman Island, such a small country, having 55,000 number of people and having investments worth 85,000 crores in P-notes? How is that possible? Why is there no question asked? And the so-called misused exemption from long-term capital gain tax, why can't SEBI regulate these transactions? Why can't, they have infrastructure, they have information. Why can't they formulate policies to regulate these long-term capital gain transactions? So globally, we've seen that the eyes have been opening. There has been a humongous amount of 6.6 trillions of illicit funds flowing from developing countries in the last 10 years. And India stands at 4th position. Standing at 4th position for this matter is not really proud. 440 billion US dollars have gone out of the 6.6 trillions from India alone. So it has become a global phenomena, and global architecture is being built to deal with this global phenomena and to eradicate black money. These oxygen-starved global economies are really looking for a solution to this menace. UN, World Bank, OECD, everyone has recognized. The answer is only exchange of information. Gone are the days for those traditional arrangements for exchange of information, DTAAs, TIEAs. They are not effective exchange of information tools. There is banking secrecy, there are those domestic laws of those countries which are being used as tax havens, which will always stop the information from flowing. So an automatic exchange was the only solution which we could look at. And India has also signed the Automatic Exchange of Information MCAA on June 3rd. So, gone are the days when tax evaders thought that they could hide somewhere. They are going to experience a hard time seeking to leak the money out of the nation it belongs to. Not only India I am talking about here. There are various other countries who are pushing in the black money in the market. And I would like to end my session with a quote from Angel Gurria, Secretary General of OECD. Very rightly said, tax fraud and tax evasion are not victimless crimes. They deprive the governments of revenue needed to restore growth. India needs growth. We're talking about policies, we're talking about Make in India, we're talking about so many things. But how far are we going by making normal changes to the tax policy? How comfortable are we making the tax environment in India? How conducive or how positive the tax environment is? One point I would want to share from the Make in India session. There has been a proposal by the government that they want to abolish all these profit-linked schemes, all these investment-linked schemes. On one side, you want the Make in India to be a hit. And on the other side, you're depriving all the manufacturing sectors from the profit-linked incentive schemes that they could have for those initial years. How do you think that people would still want to be part of the manufacturing Make in India drive? They won't see any tax benefit. Let the tax benefits stay there. Let them feel motivated from some angle. Then see the story rolling. There will be a change. And let the exchange of information flow. So I would like to end my session here. And thank you so much for being part of my session.
Isha, Sethi would now make the presentation.
Hello. Good evening, ladies and gentlemen. I know it's really late in the day, so I'll try to be as short as I can be. I want to talk to you today about inbound investment into Australia. For a foreign enterprise looking to invest in Australia, getting the right structure in place from the outset can simplify tax outcomes over the life cycle of the investment. With that said, I'd like to touch on some legal structures that are available to foreign investors in Australia, on the taxation consequences of each of these structures, and strategies that are available on exit from Australia, from the Australian market. Perhaps the take-home message of my talk, I'll just put this. The take-home message of my talk really is that there are some opportunities which can be exploited by an Indian investor, which go some way to disincentivizing participation in the black money economy. Foreign entities investing into Australia have a number of choices in terms of which vehicle they should use to invest, or use for the investment, I should say. The choice of any particular investment vehicle will depend upon a range of factors. Whilst investment structures can take the form of individuals investing directly, the use of trusts or partnerships, the two most common forms of investment are through either a branch of a foreign entity or through an Australian subsidiary. So I'll just focus on those two structures for the purposes of today. Just close that. Sorry, that's just so that you're not confused where I'm from.
Where is coming?
That looks a little bit like where I'm from. I don't have another. That's fine. Yeah, yeah. So where an overseas company carries on a business in Australia in its own right, it's obliged to register as a branch. A branch represents a notional segment of the foreign entity. Usually, a branch is desirable when either a foreign entity's presence in Australia is intended to be limited to a short term, or where all the profits from Australia will be remitted overseas on an immediate basis. The tax rate for a non-resident company is 30%, and that's a flat rate, which is therefore applicable to the Australian branch. The taxable income, of course, of the branch is any Australian-sourced income attributable to the branch, less any expenses incurred in deriving that income. And also a proportion of head office overheads may be attributed to branch operations. Where the foreign entity is a tax resident of a country with which Australia has a double taxation agreement, like India is, the DTA restricts the activities to which Australia has the right to tax. And therefore, the foreign entity can have access to the stable and growing economy of Australia, however, not be subject to the Australian tax system. Specifically, Article 7 of the India-Australia DTA talks about, the DTA was commenced in 1991 originally. It governs the taxation of business profits derived from Australia by a resident of India. So basically it provides that the foreign tax resident will only be taxed on business profits in Australia where it carries on a business through a permanent establishment situated in Australia. Now, as one would expect, this requires a consideration of the extent of the presence of that foreign company in Australia. Specifically, Article 5 of the India-Australia DTA sets out at some specific circumstances in which a foreign enterprise will be considered to have a permanent establishment in Australia. So, permanent establishment is described as a fixed place of business through which the business of an enterprise is wholly or partly carried on, and which includes especially a place of management, an office, a factory, a workshop and a branch. So in this way you can see a branch will generally be subject to Australian income tax on profits that are attributable to the Australian branch. However, where a foreign entity is not considered to have a permanent establishment in Australia, Australia will be precluded from having a right to tax business profits or income. The foreign entity will be treated as not having a taxable presence in Australia. So as you can see, it's pretty important to provide your clients with the right advice about the structure of their inbound investment to the Australian market to achieve intended tax outcomes. Now, just moving on and briefly talking about the alternative structure I mentioned, which is the Australian subsidiary structure. If no remittance of profits are required, as it's considered that profits are better applied to reinvest in the local business, in the Australian market, then taxation on taxable income will apply at the corporate rate of tax. And I say that because I say that because that's the general corporate rate of tax. If permanence is important to the business, or if the project or investment itself is long-term, then it may be more appropriate to establish a permanent subsidiary in Australia. Although such an Australian resident subsidiary would be taxed by Australia on its worldwide income, it would also be eligible for tax consolidation, which gives members of the consolidated group flexibility around attribution of losses. As for the repatriation of profits, when considering a cross-border investment, one must consider the taxation of all profits and cash flow in the investment structure. Ideally, the investment should be structured to minimise the total tax paid when profits are distributed back to the parent entity, or in some cases to the parent entity's shareholders. Now, there are several means by which profits can be repatriated to a foreign parent company. The common ways of doing so are to pay dividends, interest or royalties to its foreign resident shareholders. However, such payments are generally subject to Australian withholding taxes pursuant to Section 128 capital B of the 36 Income Tax Assessment Act, if you are interested. Profits earned in Australia may be remitted to a non-resident entity by way of dividends. Now, dividends are only applicable in a subsidiary structure because in a branch structure, there is no formal repatriation of profits anyway, or it's not necessary, because the branch is only a notional segment of the overall entity in the first place. So, per Section 128 capital B, again of the 36 Income Tax Assessment Act of Australia, dividends paid by a resident company to a non-resident are generally subject to dividend withholding tax, which, pursuant to the India-Australia Double Taxation Agreement, cannot exceed the rate of 15%. However, the extent of withholding tax will apply only to the extent that the dividend is unfranked. Now, most of you, I'm sure, will understand the concept of franked or unfranked, but as you know, dividends can either be fully franked, partly franked, or completely unfranked. If the resident company has returned tax to the Australian Taxation Office, say at the corporate rate of 30%, it would have generated franking credits to that same extent. So those credits can then be applied towards reducing the amount of tax withheld on the distribution of dividends to the non-resident entity. As for interest, profits of an Australian company or branch can also be repatriated by way of interest on debt obligations. Section 128 capital B of the 36 Act provides that interest paid to a non-resident by a resident company or a branch of a non-resident is subject to interest withholding tax. Interest withholding tax is payable on the gross amount of interest paid or interest credited to the non-resident. It operates similarly to the dividend withholding tax. Broadly speaking, the relevant rate of withholding tax will be 10% on the gross interest payment, and the Australian resident paying the interest is obligated to withhold the interest withholding tax. The rate of interest and the quantum of the loan should also be set having regard to Australia's transfer pricing rules and thin capitalisation rules, which I won't go into for today's purposes. Now, lastly, management fees. So, alternatively, Australian source profits may be distributed to foreign resident parent companies through the payment of management fees. Now, unlike dividends, interest and royalties, the payment of management fees is not subject to withholding taxes. Repatriation of profits could also take the form of management fee charged to the Australian resident subsidiaries, representing the arm's length charge for administrative and managerial services and support provided by the non-resident parent company, provided that the payments are not regarded as being royalties. Withholding tax should not apply. The management fee must be charged at an arm's length rate based on the level of services, risk and resources of the provider. The rate charged must be able to withstand scrutiny under a transfer pricing review. Where the management fee charged is considered to be excessive with regards to services provided, the Australian Taxation Office may take the view that the management fee is not a deductible expense. Now, where the management fee is excessive, it arguably may not be considered to be inappropriate or adapted for the ends of the business and hence not incurred in the carrying on of a business, hence the inability to deduct it against assessable income. Now, once the life of a business nears its end, one must consider exit strategies. This is often an area overlooked when considering cross-border investment. Where exit planning has not been undertaken, higher than necessary costs associated with taxation may be incurred, or last-minute, often risky restructuring becomes necessary. The key operative provision in relation to exit from Australia for foreign entities is Division 855 of the 1997 Income Tax Assessment Act. Now, Division 855 was introduced in 2006 with the intention of encouraging foreign investment into Australia by narrowing the scope for which capital gains made by foreign residents are assessable. The changes, which took effect on 12th of December 2006, aligned Australia's domestic law more closely with the scope of Australia's double taxation treaties. Division 855 generally provides that foreign entities are subject to capital gains tax only to the extent that the capital gains or losses arise from a CGT event relating to assets that are taxable Australian property. The provision allows a foreign resident or trustee of a foreign trust for CGT purposes to disregard capital gain or capital loss from a CGT event with respect to a CGT asset that is not taxable Australian property. Consequently, foreign residents are only subject to CGT in relation to assets that are taxable Australian property. So as you can see, there are a range of opportunities that are available to inbound investors, which, if carefully understood, can be applied to the benefit of the investors. Thank you very much.
Thank you, Ishita. Now I would request Mr. Maran to talk about tax evasion in Australia.
Thank you. The time now is
10 minutes.
10 minutes. I'll finish it within 10 minutes. I promise. Mr. Chairman, fellow colleagues, Ishita, Neha, and Mr. Krishan, good evening. On behalf of Law Society of New South Wales and Legal Fraternity of Australia, I wish Namaskar. Thank you for having us today here in this forum. Black money, if you were to come to Australia or New South Wales, any part of Australia, and to mention black money among the lawyers, they'll be very confused because we don't use the word black money there. But there is another term. The term black money. There is a black money. There is a black money, but the term we use is different. Let me tell what I have prepared here. We say that base, note this word, base erosion and profit shifting. It means base erosion, thank you. Base erosion, it means base, it's not outside Australia, and profit shifting. So we use a different term, yeah. So when I was given this topic last week, we were doing some research, and then the act was passed, recently. In May it was, and then July it became an act. Yes. Well, okay. Uh, in, there are, in Australia, we have the tax evasion problem starts way back from last century. In Australia, tax crime occurs when an individual fails to disclose information, when they define what is tax evasion. So the definition they use is a crime. It becomes a crime when an individual fails to disclose information regarding tax for the purposes of or having financial benefit. So it must be having some sort of benefit to the person who is inflicting to him or to the company or the corporation. The two types of tax schemes are procedures. It's in view of the 10 minutes given, I'll just bypass all this. I prepared two texts, one lengthy, one is very short one. So okay. So I'll go through straight away. Tax avoidance in Australia has been an ongoing challenge from later 1990s. The 1987 annual report of the Australian Taxation Office, ATO, is very popular in Australia. ATO, you just mentioned ATO, everybody has to go through ATO. Australian Taxation Office stated that tax avoidance scheme involved some 6,688 companies, about 7,000 companies, and resulted in tax evasion of between 500 million to 1,000 million. The largest instances of fraud committed against the Commonwealth government. So it's about 7,000 companies, corporations. Okay. Tax evasion harms governments because they have to cope with less revenue. Base erosion and profit shifting are becoming a greater concern for Australian government. BEPS is when a company deliberately vanishes income from their financial report and shifts their profit to an offshore account known as tax haven in order to disclose reduced profit within Australia or in any other country and thus pay less tax. The Australian Taxation Office aims to increase tax transparency because there is a growing concern among the community. So we have the Australian taxation aims to increase tax transparency because there is a growing concern. Large corporations are participating in aggressive tax avoidance schemes. So how do we manage? First, practices of detections are becoming continuously difficult, very difficult because of the advances in technology, e-commerce. So the advances in technology makes the tackling BEPS or black money complicated. So law reform and collaboration within the growing network of local international partners, technology which includes data modeling, tracking and matching acts as a detection method to identify illegal behavior. The Australian law and ATO's administrative framework work together. We have Marsh lawyers always have, we have a quite sizable number of clients from Australia, from India, from Delhi, Punjab, who is investing in Australia. And the common questions we ask, sir, can we sign a contract? We state one amount, 1 million or 2 million, and then, but on the document we'll just state, but actually the transaction is 10 million. So these type of things will never happen in Australia because of the torrent system. I think if you are serious to tackle black money, you must compare the torrent system. The torrent system, property law in Australia, we apply torrent system which locks all these problems. Within 42 days, let's say you're buying a property in Delhi, you're selling, and someone is buying, the whole settlement must happen within 42 days. I think Ishita will agree with that. So 42 days, and from the day or everything, before the property is being sold, we have a stamping, all are documented, all electronically. So there is no any, these are one of the areas which we are trying to tackle. We are successful in that. Australian torrent system is more than 100 years old and it's being applied in many countries now. Malaysia is, I'm actually born from Malaysia. From Malaysia, then I went to Sydney. So Malaysia has successfully implemented. We copied, Malaysia copied, and we're very successful. Okay. As stated earlier, ATO is trying to create greater tax transparency. A great example is the recent amendment to the Taxation Administration Act 1953, which requires organizations, very important, which requires organizations with a total income of 100 million or more to disclose information to the public. Anyone gets more than 100 million, it must be stated in public, it will be published. And the information is as follows: ABN number, business registration number, total income for the year, taxable income, and income tax payable. So all this must be disclosed to the public. Not complying correctly with the Australian Taxation Office requirements or disclosing incorrect information can lead to reputational risk and negative publicity. So this is one way to induce them, like big companies like BHP and Rio Tinto. So they take an approach, so their reputations will be affected. So we have these strict laws. Everything is available in the internet, so I need not to go in detail. It's sufficient if I say there are some tax acts were passed: Tax Administration Act 1953, Tax Assessment 1936, Tax Assessment Act 1997, and as recent as 2014. So we can see the trial and error basis. So the Black Money Act has just recently been passed. So you will go through a lot of trial and error, and in the future, I would rather suggest if there were comparison, maybe the next sections when you have how the comparisons can be done, adapted by these countries in Asia Pacific. Just before I conclude, black money, tax avoidance and tax evasion all account for extremities where tax payable is avoided through particular means from individuals and corporations. The steps taken to stop and prevent these acts in both India and Australia have been significant and have provided a strong foundation on what we can hope for the onset of for a future without where the issue is significantly decreased and black money's power, decrease the black money's power in the economy. With this, I conclude. Dhanyavad.
Yeah, certainly we have, the Q&A also. Thank you very much. I'm going to share about what are the initiatives, as we have been seeing that as far as the India is concerned, there are the biggest roadblocks, especially after the Vodafone, when there was a great Supreme Court judgment and then the law was amended retrospectively, which was criticized, and it was on the hit list of almost all the investors across the globe to look at India, and it was not really very well appreciated. And India has been infamous for different things, especially mainly for the litigation and especially for the tax. And in the tax sector itself, once this transfer pricing was introduced, it was more focused on, transfer pricing disputes. So when this new government came 18 years back, I think the first and the most important thing for them was to look for the development. And they took this as an initiative to say that we need to set the things right as far as the taxes are concerned. So I'm going to share with you some of the initiatives which they have taken, because what we hear, the words like tax terrorism, we talk about aggressive attitudes, we talked about retrospective amendments, we talked about irrational demands. These are the things which are quite famous, and these are the buzzwords as far as Indian taxes are concerned. So therefore, government at least recognizes that there is a large number of litigation which is pending. Just to share with you, 1,80,000 crores of rupees is locked up in appeals. If you look at, there are 77,000 tax cases which are, pending. And if you look at the bifurcation, 37,000 in tribunals, 34,000 in high courts, and more than 6,000 in Supreme Court. And people are bound to make the payments under the protest. And the cash is rich. It's a king. as on date when we see there is a recession. So therefore, it is very difficult for people to take the money out of the system and make the payments in taxes. And once the payments are gone, even if you win in the first level of litigation, you cannot get the money back from tax authorities. So these are the problems which really made government to think through to say that we need to recognize that how we can reduce the litigation. And some of the initiatives, some of the measures which they have taken, I am going to share very briefly with you. In terms of acceptance of justice, as you have been hearing, there has been a big news in the newspapers that all the FIIs are facing problems in context of MAT. They don't have any presence in India. They are not making any profit and loss account in India, but still they have to pay the tax on their book profits. When you're not maintaining any books, how would you pay the taxes on your book profits? There was a huge demand, hue and cry, a few crores of demands was raised. So I think this government, what they did was they came out with a panel which was headed by High Court Judge Mr. Shah. So AP Shah, he came out with a report, and after the report, the government clarified the issue that no MAT would be paid by foreign FIIs who are making investment in India in shares prior to 1/4/2015, because in 2015 onwards, under the budget, government brought that way forward, nothing would be paid by them. So the tax authorities interpreted that it is way forward, it means previously it was payable. So therefore they started reopening, they got hold of some more than 500 FIIs and started initiating such proceedings. So that was clarified that even the amendment was made from 1/4/2015, even for the earlier years, MAT would not be paid by financial institutions who are making investment in shares. So I think that was a very major step which they took. Government has recently, in October, they have come out with a committee of 10 members, and that committee would simplify the provisions. And that committee would be headed by none other than who was there last time, our ex-judge who was looking after the tax bench in Delhi High Court, Justice R.V. Ishwar. He is going to head this committee. There are people taken from industry, there are professionals who are taken. So they have set up this committee to look at the words where there are a lot of interpretational debates in the law, where there is an ambiguity, it needs clarity, and they have been instructed to come out with a report by 31st of January 2016. So there appears to be a clear intention to have this report and see what government can clarify by way of a budget which is expected on 28th of February 2016. So that's again a great step. I think that would really help us because most of the litigation is based on the interpretations. And if the intentions are to simplify the things, I think that's a very great initiative. Now, you all talk, you would have heard that Vodafone, in the case of Vodafone, when the parent made investment in subsidiary, they said that the shares were issued to the parent, probably it was issued at a book value, not at a market value, and the difference should be treated as income. How come issuance of share capital would fall under the head income? But that is the stand which was taken in Vodafone, that is the stand which was taken in Shell, and the matter went right up to the Bombay High Court. So in October 2014, Bombay High Court came out with a judgment that when you issue the shares, there is no question of having any income. And certainly the transfer pricing rules would not be applicable. It was a major judgment, and certainly blindly in the past we have been seeing for last 60 years, government file an appeal because there is no accountability. Government came out with a clear recommendation to the department, and they issued a circular to say that this decision is a good decision. I don't think that government should take an initiative to file an appeal in Supreme Court. And then simultaneously they gave instructions to the authorities that please don't raise any demands, conclude any assessments, you respect this Bombay judgment. It was a classic example which really saved Vodafone as well as Shell, because those were absolutely frivolous demands. It was non-application of mind, they were bad orders, but first time we found that they took this initiative and they publicized the same and they instructed their officers. Similarly, those who are from the film industries, when you abandon your films, you incur a lot of expenses in creating films. And when you abandon, will it be a revenue expenditure or a capital expenditure? Authority said they are abandoned films, so we will not, you cannot claim this expenditure. Again, Bombay High Court came out with a judgment. Again, the department issued a circular and said, you respect this judgment, we will not go in appeal in Supreme Court. And I'm sure both these things happened during this year, so they would make an appropriate amendment in the budget. So I think this really suggests that government is really serious, and now they are trying to curtail how things can be controlled in terms of making frivolous demands. The other thing is they have enlarged the scope of settlement commission. Now, if assessee who is facing a lot of problems, they can go to the settlement commission. But if your cases are open for last 8 years, 6 years, 4 years, you can't go to the settlement commission. If commissioner opened your assessment, he found something which has gone against revenue, you can't go to the settlement commission. In the last budget, they clarified no. Even in those circumstances, you can go to the settlement commission, things would be handled separately and that would be settled through the commission. Similarly, for advance ruling, before you do any business, foreign companies have an opportunity to go and take an advance ruling and take a decision upfront. But that facility was not provided to domestic players. So that's a very great step where they introduced last year and said, even this advance ruling would also be available to the domestic players if they don't want to get into the litigation. Before they execute the transaction, they can go to the advance ruling, the courts, and can take the ruling upfront. So that's a very good step again in order to reduce the litigation. As somebody was talking about, in the case of transfer pricing, there is a mechanism that you can have a similar which is known as APA, that you can take an advance ruling for next 5 years. Now the issue is that for last 3 years no APAs took place. In last 6 months 31 APAs have already been passed. Usually I was talking to somebody from Japan, usually it takes 3 years to conclude one APA, 2 years to conclude one APA. Government resolved now with clear instructions to conclude it. 31 APAs have already been concluded and more than 400 applications are pending, and government have given clear instruction to clear as early as possible, and now full teams are devoted exclusively. Yes.
Are these scrutinized properly or in a hurry they are being passed?
No. I think there are now proper teams and they are not doing anything in hurry. If you look at it, they have been working for for almost 1.5 years. They have now expanded teams, even they are using the services of economists, and they are not doing it hurriedly.
Because last year I remember there were only 2 APAs which were passed.
But now there are 31 and they are bilateral, because there are 2 types of resolution. One is unilateral. India took a stand whether US took or not. But now one APA which we had with Japan, where both the governments agreed to resolve the issue in the same fashion.
This happened recently as well.
Very recently. I beg your pardon, sir? No, that's the order. So you have a subsidiary, here in India, you come from Japan, you are doing some transaction with your related party, you said I wanted to charge 7% profit. And you will give a complete reasoning to justify that.
I'm not satisfied with the reasoning, for example.
But in case if you're not, then there would not be any APA. But if APA is resolved,
Can't it be settled by a higher authority?
no, APA is the highest authority. Is the highest authority. It is in a highest authority where they will ask for the data. It takes 1.5 years to give enough data. They examine, you have rounds of meetings, discussions, and then they come out with a ruling to say that is what we intend to do it. And then you will execute your transaction once you have a ruling in hand. Or if you have already started, you will put it on hold and no assessment will be done because your matter is still pending in APA. That's interesting. So it's not that something, demands are raised and you are fighting. It's not similar to the way things are taken place in high courts or when you are in the litigation in the courts. It's very different. So I think it's great. Then if you come into this,
as you said, really settled or not, at least 10% of the cases can be put on test check, so that it will be a deterrent on the part of the people not to come to the other side of the things.
Now the only thing is the orders have been passed, and after the orders are passed, certainly the officers would have to respect that. And the law is very clear, if there is no change of circumstances, then this order would be applicable for next 5 years. If you make a change, you do operations differently, the circumstances have become different, certainly you can always go for the revision. But now how it would be implemented, how the order would be respected is something which would be seen in years to come. But the thing is that without getting into litigation, you have an order in advance, you know how your transaction would be taken up by the authorities. Active participation in BEPS, as somebody talks about base erosion and when we say profit shifting, India is one of the G20 countries. Although we are not member of OECD, but we are there as an advisor and we are one of the G20 countries. So therefore, a lot of action has already been taking place. One report has already come for OECD, and it is not only India which talks about it. America is the biggest, because look at Apple, you look at all the American, look at GE, look at Google's, none of them are paying any taxes in America. They have moved their operations in Ireland, they have moved their operations in Starbucks also. So they have moved their profits, they have moved their all subsidiaries in Ireland, which they moved their subsidiaries in Netherlands. These are the two places where especially all American companies have created the companies and shifted all their profits. They have transferred their patents in different countries to avoid any, so whatever they are generating, they are hardly paying any taxes in US, and everything appears to be settled. That's why now even America is now little aghast to say that all big players who are doing global business across are not paying any taxes or paying minimum taxes in US. So therefore this G20, which is a group where they are committed to put everything in place by 2020, and based on the report, government would make amendments in the local law so that all the countries work in the same direction on the same platform.
How India adapts to it?
No, as far as India is not a member of OECD, but we are member of G20. So in a way, if you look at it, we can have a separate session. India has already implemented what this report is telling. We have already made amendments in last 2-3 years, because we are the biggest sufferer. Everyone wants to do a business in India, but nobody wants to pay the taxes. Today, if there is someone from IT, all R&D in the IT is taking place in India. We are showing it as export of services, and all the copyrights are out of India. Whereas our youngsters, our brains are sitting creating all the new great patented items. But all the rights are held by American companies somewhere in Netherlands or somewhere in Cyprus. And we are not getting any benefit. So I think these are the concerns which Indians are aware of, and they are making changes on that. Black money law has already come. When this was there, people were a little confused. They have not supported greatly, but certainly government came out with FAQs with the questions to answer, to remove the doubts. Government has come out, as somebody was telling, that now we wanted to reduce our taxes over next 4 years from 30% to 25%. If you look at it, China is 25, Singapore is 16, Hong Kong is 19, and if we are competing with China, we need to come at 25%. Because of exemptions, our effective tax rate is 23%. Our rate is 30%, with surcharge it becomes 33%, but our effective rate is 23% because of, so they wanted to remove these exemptions. What for you need an exemption? India is no more a country, and where I would like to respond, I fully agree with that, because India, people are not willing. If our Prime Minister has gone to Germany, if he has gone to Japan, if he goes to US, if he has gone to all these countries which have a high technology for infrastructure, for defense, they are all willing to come, not because India would provide them some incentive, because India has a lot of opportunities, market is big, they will get a huge returns from India because of the quantum of business which they will get it. So right now people are looking for India not to get any tax benefits, but look at India so that they will get a good volumes. It's a volume game. Infrastructure, we need infrastructure not in one state but across India. We need roads all over. So if we work sincerely for 9-10 years, there is a huge market in India. So therefore people are looking at a market and opportunities, not at tax incentives. And it's a right step. We have been hearing it for last 15 years, but no government has done it. So I really appreciate this is a right step. And that's what we should now, being an Indian, should have a confidence to say that people are not coming for incentives. We are not a Taiwan, we are not Vietnam, we are India. So therefore we have people, and we have, so therefore it is important now this tendency is right. Then I come to revised guidelines on transfer pricing has come. As I was sharing, there are 4,000 disputes which are pending in transfer pricing. Focus is on high risk now, not on the volume. If the transaction is more than 20 crore, you would be selected for scrutiny is not the case. What kind of structures you have, how much risk is involved, they have come out with the guidelines, what kind of documentation you have to maintain. I think this will really help to a great extent. And if you will look at it, maybe some of the people are from industry, in last 3 months, there are 4 notifications which has come. Just to avoid frivolous demands. Now, how it would be implemented is something different. Government has come out with a guidelines for departmental representatives who appear in the courts or for advance ruling. They don't come. The matters are pending for last 5 years because every time the man from department will come that we need an adjournment. An adjournment is granted. Now they come out, no such adjournments would be given. You will have to conclude the matter within timelines and their promotions, everything would depend upon that. That is the first guideline which has been issued. Second guidelines they give, no frivolous demands would be raised. Every demand which would be raised would be subject to the principal commissioner. And thirdly, they are saying they have come out with a local committee to deal with they are in every city, big city, there are going to be committee. If you being running a business, finding any problem, you file the copy of the order before the committee. Committee will contain chief commissioner, commissioner and somebody else in the hierarchy. And you make a presentation that how the same has been done and the committee has to pass an order within 2 months. So now there is someone who is going to hear it. This is the mechanism they are trying to create. They are come out with 250 Ayakar Seva Kendra where you can go and file a complaint. So I'm thinking action is there, direction is there. How it would be implemented and how seriously it would be taken is something is to be seen. So these things will certainly reduce litigation, frivolous demands, unmindful orders, and then mechanism for the timely redressal of the taxpayer grievances and a public delivery system. Then if you look at it, some of the changes which has been made now in the budget, in last budget, introduction of dispute resolution bill, where they wanted to introduce public contract resolution of dispute bill to streamline the institution arrangement of such disputes, raising threshold limit of applicability of domestic transfer pricing law. Initially the transaction, anything above 5 crore would be taken up for domestic. Now they have increased the limit from 5 crore to 20 crores. And my feeling is 70% transaction may go. So, which is a good step. Defining the word substantial. Any transfer, like in the case of Vodafone, if any transfer of share taking place between 2 shareholders sitting out of India, but the underlying assets are in India, substantially, that transfer of share outside India would also be taxed in India. This is exactly what the Vodafone is. But what is the word substantial? There are many judgments. Somebody says 20%, somebody says 35%. Now government has come out in the last budget said any valuation which is in India 10 crores and 50% and above. So if there is a transfer of shares in New York Stock Exchange for any company whose underlying assets are 50% and above in India, even though the sale is taking place outside India, you will have to pay the tax. End of the matter. Simple clarity. So they have defined the word substantial. And there are 20 judgments on defining what is substantial in past 4 years. So now at least the law has come. They have explained what the substantial is. Then we talk about, this is last slide. So I would just share that what all they have done it here, rollback mechanism of APA. So if you are struggling, as somebody asked, there is an APA, you gotten a ruling for next 5 years. Same ruling you can apply for earlier 4 years. This is called rollback.
This came last budget.
This came in last budget. This came in last budget. So that is something which came in 2014, where they rightly did that. Why not? If the facts are same, circumstances are same, apply the same judgment and get out of litigation. Concept of range and multiple year data, which also came in 14 as well as in 15, where we use multiple data. Assessee use multiple data to come at the arm's length price, not the single data. So say you shoot multiple data. We were computing average mean. Now they are saying you go with the in quartile range. In quartile range is much stronger. So they have now made the amendment to say, in order to arrive at arm's length price, you can use multiple data, not for 1 year but many years, and you use in quartile range. That's very good important thing. Even when we Indians are doing business in Australia or doing a business in US now, we are going out and starting factories. Transfer pricing is not important for Nokias and Samsungs of the world. It is important for us now. A lot of Indian entrepreneurs are opening offices in Singapore. So if you are two related parties are doing transaction, it will help how to compute the arm's length. So there is a certainty now. Safe harbor rules were introduced 2 years back. The rules are out now. And as I said, mutual agreement procedure under the double taxation treaty, any issue which is pending in the court, if you wanted to resolve out of the court without withdrawing your appeals under double taxation treaty, you can, Ministry of Finance, you can file a letter with your application. It would be taken up with the Ministry of Finance of that country. They will sit and resolve between the two ministries. If they agree, that is called mutual agreement procedure. If you agree to resolve that issue, then you sign an agreement, the government would pass necessary orders and you withdraw the appeals. So you can take your litigation out of the court to resolve the issue out of through mutual agreement procedures under the treaty. So I think it was there for last many years, but as we know, for last 3 years there was hardly anything done with US. Now more than 100 cases are resolved in last 6 months as far as US map is concerned. So overall, if you look at it, I think there is enough which I should not say there is enough which is done. There is a clear intention. Few steps, initiatives have already been taken, and I am sure that if more initiatives would be taken, I am sure if those initiatives which government has taken would be implemented seriously by the authorities, certainly we will see the things which right now the big roadblock, Indian income tax disputes, Indian transfer pricing, which scares people to come to India, I think would gradually wipe out. Thank you very much. If now we all the panelists are here, so if you have anything to ask, just feel free to. Yeah, please. Yes, sir.
सर मेरा सवाल है कि आपने दो पैनलिस्ट ऑस्ट्रेलिया के हैं, बाकी आप इंडिया से हैं. 2005 I was in Switzerland on official tour. I came across so many officials of Switzerland. I don't want to quote the name and designation, whatever. So as a journalist, I'll just talk as a sources. I just went to Bank Street also. I have seen. They, after talking, I think 20, 25 senior officials, political leaders of Switzerland, I was talking about how the black money, how much black money of India in Switzerland and other countries. Answer was, Mr. Kumar, there is no policy such you can back the money from Switzerland. मेरा सवाल फिर यहीं से शुरू होता है. अपने पास जो डबल टैक्सेशन ट्रीटी की बात कर रहे हैं, उसके बाद जो भी डेवलपमेंट हुए हैं शाह कमेटी के बाद, क्या हमको लगता है कि हम जो काला धन लाने की बात कही है सरकार ने, वो संभव है? एक दूसरा, 2 साल पहले आदरणीय राम जेठमलानी जी ने एक 2.5 साल हो गए IIC में सेमिनार किया था. वहाँ उन्होंने पूरा फिगर्स दिया, जो इशिता का फिगर था, जो नेहा का था, जो आपने बताया, जो सारे टेक्निकल्स. वहाँ एक व्यक्ति कनाडा के बैठे हुए थे. मैं 2 रेफरेंस इसलिए कोट कर रहा हूँ कि थोड़ा मैं समझना चाहता हूँ उस चीज़ को. उन्होंने कहा, साहब मैं पैसे लेकर के, वाइट मनी लेकर के 5 करोड़ रुपए लेके आया और मैं मकान खरीदना था. 6 महीने तक भटकता रहा देश में और वापस चला गया. तो जस्ट थोड़ा सा थ्रो करें लाइट की, कैसे संभव है, हाउ इज पॉसिबल टू come the black money should come India, either how we can work with the white money in India.
बहुत अच्छे, आपका बड़ा अच्छा सवाल है जी, मैं इसका जवाब देता हूँ. इसमें देखिए 2 चीज़ें हैं. जहाँ तक मैंने डबल टैक्सेशन ट्रीटी की बात की है, as far as the treaty is concerned, there was no article for exchange of information. Now India has signed almost 100 double taxation treaties with 100, the countries. All the new treaties signed in last 3-4 years are all signed with a clause for sharing of information, which is binding. Number one. Old treaties have already been revised. Few years back, it was India's requirement to get information. Why the G20 big great 20 countries are sitting together, their finance ministers are going every 6 months and spending 3 days, and a lot of people are working on this, because we have a problem of black money, but they believe that they are not in a position to collect the taxes. If we have a black money, the net point is there is a flow of the money which cannot be used productively. Correct. No, so I'm saying we will come to right now, since you asked the question on exchange of information and you gave an example of Switzerland, what I'm saying is कि पहले हम लोग पैसा बाहर लेके जाते थे, एक तो वो पैसा सर्कुलेशन से बाहर जा रहा था और उस पर टैक्स नहीं मिल रहा था, दूसरी कंट्रीज पे उसका कोई इम्पैक्ट नहीं था. अब पिछले 5-6 साल में जब से डिजिटल इकोनॉमी शुरू हुई, इंफ्रास्ट्रक्चर की कंपनीज में अलग अलग ट्रीटी साइन हुई, लोगों ने अलग अलग जगह केमन आइलैंड्स और साइप्रस जब वहाँ धंधे शुरू किए, अब उन कंट्रीज को भी हमसे इंफॉर्मेशन चाहिए. आज की डेट में द नीड इज नॉट ओनली फ्रॉम इंडियन पर्सपेक्टिव, देयर इज ए नीड एंड ऑल दिस ब्लैक मनी इज रोटेटेड or used by the terrorist. So therefore, it has become now impedient and very important for other countries also to share the information. So once this information would be shared, it will not be possible. And the FATCA law which America has brought in, if you are an American, that is why so many Indian brothers are now leaving their American citizen. You cannot open a bank account. Whatever investment you have worldwide, you need to share it. So therefore, the kind of information which you require to open anything out of India, I am not saying it is impossible. Still there are so many loopholes, but it is not easy. And once we have under the treaty to share information, हमसे मांगेंगे हम देंगे, हम उनसे मांगेंगे वो हमको देंगे. जब ये प्रोविजन कंट्रीज ने साइन कर लिया और OECD के कहने पे G20 में कमिट करेंगे, तब जब इंफॉर्मेशन शेयर होगी तो वो चीज़ें जो पहले छुपी हुई थी वो अब वैसी नहीं रहेंगी. नंबर वन. तो उसमें ब्लैक मनी का, बट इट्स ए प्रोसेस. ये वो कोई मैजिक स्टिक नहीं है कि 15 महीने पहले सरकार ने कहा हम लेके आएंगे और ऐसे घुमाओगे तो वो सब पैसा आ जाएगा. एटलीस्ट इसमें डेलिब्रेशंस हैं, इसमें स्टेप्स लिए जा रहे हैं. इट्स ए प्रोसेस, वन बाय स्टेप. सभी के पास है, सभी के पास है. मैं साधु
TAAs or TIEAs that are the solution. The automatic exchange of information is the long-term solution. And when the information will start flowing annually on an automatic basis, India will have enough information. Rest assured, people would not be able to hide.
It is hopeful. It is hopeful.
We are hopeful that India would have enough information to catch all of them.
So what has happened with the Ministry of DTA?
कोई 80 लाख करोड़ बोल देता है, कोई 80 करोड़ बोल देता है, कोई 80 बिलियंस बता देता है. इतना पैसा है. ये क्या है? ये मेजरमेंट का जो फिगर्स है ये कॉन्कॉक्टेड है या उसमें कहीं कुछ इमेजिनरी फिगर्स है या मतलब इसका कोई बेस तो नहीं है. नोबडी कैन जस्ट सर्टिफाई.
ये सारी एस्टिमेटेड फिगर्स हैं जी. और एक चीज और देखिएगा आप, पैसा तब गया जब
इंक्लूडिंग नेम ऑफ द पॉलिटिशियन जो व्हाट्सएप पे जहां
आई एम नॉट ऑन इंडिविजुअल्स, वो सेंट्स हो, पॉलिटिशियंस हो, एक आम आदमी हो, नो वन इज क्लीन. सो वी आर नॉट ऑन इंडिविजुअल्स. ब्लैक मनी तब गई जब इंडिया की इकोनॉमी डेवलपमेंट में नहीं थी और बाहर बहुत अच्छी डेवलपमेंट थी. आज अगर आपके पास भी 10 करोड़ रुपया पड़ा है तो आप 10 करोड़ में ज़्यादा कमा सकते हैं अच्छा इंडिया में, बजाय कि बाहर कहीं आपको कुछ मिलेगा. सो अब कोई इंसेंटिव भी नहीं है कि पैसा बाहर रखना और पैसे के ऊपर आपको कुछ उसमें कुछ और वो करना, क्योंकि आपको कोई इंसेंटिव ही नहीं है बाहर ले जाने का.
बैंक ऑफ बड़ौदा का नया केस, मल्होत्रा साहब, बैंक ऑफ बड़ौदा का नया केस है कि पैसा जा रहा है, आ कहाँ रहा है?
अभी इंडिया में ही रहा है सर. अभी इंडिया में ही रहा है. इज दिस क्वेश्चन.
सो आई थिंक द टाइम इज ओवर. प्रोवाइडेड टाइम इज ओवर, इज फाइन. वी कैन हैव ऑफलाइन प्लीज. थैंक यू जी. थैंक यू वेरी मच.
After such a wonderful session, I like to call on stage Ramaswamy sir to kindly felicitate the panelists. I request sir to kindly felicitate Mr. Krishna Malhotra, Head Taxation, Amarchand and Mangaldas. And I like to call on stage Kumar Rakesh sir, Editor-in-Chief, Global Governance News Corp, to kindly felicitate Ms. Ishita Sethi.